A criminal case in Houston is going to be resolved one of, say, 6 ways, depending on what kind of case it is, whether it's a felony or a misdemeanor, and depending on the prosecutor. Option number 1 would be a pretrial diversion. Pretrial diversion generally is a gentleman's agreement between the state and the defense that says, you know, this is a good guy. He didn't mean to do it. He's got a perfectly clean criminal history. He's an upstanding member of the community. Why don't we do this? Why don't we reset the case for a couple of months? I make my guy go take an anger management course or batteries intervention program or some kind of therapy. For example, if it's a domestic violence case, he comes back, shows the certificates, and you guys dismiss the case altogether. That is a very good option because that can be expunged. That can be completely wiped off your record. Option number 2 is a more formalized agreement like that, where it's usually referred to as a PTI or a pretrial intervention, where the individual signs a contract. And the conditions of that contract mimic conditions of probation, meaning the case is reset for about a year. During that time, the accused is placed under supervision. He's got to follow certain conditions, random UAs, do community service, take classes, things like that. But again, if he does what he's supposed to do, at the end of the term, the case is dismissed. That one also can be expunged. Doesn't even have to go in front of the judge. Option number 3 is deferred adjudication. Deferred adjudication, he does have to go in front of the judge, and he does have to plead guilty in open court. And the judge will say, I hereby find there's enough evidence to find you guilty, but I defer a finding of guilt for X number of months or X number of years, depending on whether or not it's a misdemeanor or a felony. That functionally is exactly like probation. You get a PO, you got to report in once a month, you got to do random UAs, pay fine, court costs, community service, et cetera, et cetera. But if you do what you're supposed to do, at the end of the term, the case is dismissed. Now, because you went in front of the judge, that cannot be expunged, but it can be sealed. You can file a petition for non-disclosure, which basically seals the record with regard to private companies, academic institutions, credit bureaus, apartment complexes, things like that. So if later, if you join the military, need a security clearance, it might come up. If you need an FBI background check, the arrest might come up. Not that you were convicted, but that you were arrested. So on any employment application, if it asks if you've been convicted of a felony, you can honestly say no because you did what you were supposed to do and the case was dismissed. But if the call of the question is, have you ever been arrested for a felony? That's a different story, and you have to decide whether or not that company has the resources to find a case that has been non-disclosed. Option number 4 is straight probation. Probation, all that does is it keeps you out of prison. It is a final conviction with all of the consequences that a conviction entails. But again, you have to report in once a month. You get a probation officer. He's allowed to come to your house. He's allowed to come to your work. You got to do random UAs, pay fine, court costs, do community service, classes, whatever the judge or the evaluation says that you have to do. Understand in both of those, if you violate even one condition on deferred adjudication or probation, the judge can revoke you and send you straight to prison. Now, he may not, and I'll discuss those consequences later in a different video. But understand that however long you're on supervision, that means your life has to change completely. No drinking, no drugging, no picking up new cases. Because if you do, they will revoke your supervision and send you straight to prison. Option number 5, they do a reduction. Say if it's a felony, they reduce it down to a misdemeanor, which is very, very difficult to achieve. But sometimes you can reduce a felony all the way down to a misdemeanor. They could offer a time served, reduce it down to a misdemeanor and give you time served for the time you were in the county jail. They could offer you from a higher level felony down to a minimal felony, a low level felony, which is a state jail felony, and they could offer you 1244A. 1244A is a section of the code that only applies to state jail felonies, but it allows a person to serve their time out in the county jail as opposed to going straight to prison, going to Huntsville. But it is a final felony conviction with all of the consequences of a felony conviction. If it's a misdemeanor, again, they can offer you time served, which is a final conviction. But the upside of that is the case is over with that day. You don't have to report in. You don't have to do anything else. But it is a final conviction on your record that you'll never be able to wipe away. It'll be there for the rest of your life. And then, of course, option number 6 would be going to trial, which is always an option that you have. But you need to consider what it is they're putting on the table and what you can try to work out before you decide to go down that route. And I will explain later in a different video some of the things to consider on whether or not you go to trial. But if you have a case in Houston, Texas, chances are it's going to be resolved one of those 6 ways. So hopefully this information helped out a little bit, and I appreciate you taking the time to listen. Have a good day.